I can summarize it pretty quickly. The debtor can't do any of those things without the court's permission. So let's start with using. One of, and perhaps I should take a step back and say, one of the things that we have to do at the beginning of a Chapter 11 case is file and get granted what are called first day motions. Now, in spite of the name, they don't have to be granted on the first day of the bankruptcy case, but they do have to be granted pretty quickly. One of those motions that's fairly typical is something called cash collateral motion. This is a simple example to illustrate what cash collateral is will help. Let's say that the debtor has a piece of rental property and is renting it out. Well, the mortgage holder on that rental property undoubtedly has an assignment of rents provision in the mortgage documents that says that as a renter is paying the rent, the mortgage company has a claim against that money, that rent that's coming in, because unless there is no mortgage, which is somewhat unusual, the mortgage company, the bank, is entitled to have that money. Once the debtor files for Chapter 11 protection, that money can't be used. That money can't be used for anything. It belongs to the bank. So we have to get the court's permission for authority to use that money, and that is done through a cash collateral motion. And they can be blanket motions, or they can have various time limitations when you get to use cash collateral for so and so much time, but then you have to come back and ask for another authorization. So that is a simple example. Certainly there's a payroll motion. If the debtor is a business that has employees, well, the money that's available, the creditors may have claims against that money. For example, if the debtor is in the business of buying merchandise and turning around and selling it, the creditor or the vendor who sold the debtor that merchandise has a claim against the money that is being paid by the customers to purchase that merchandise. Well, the debtor would like to pay the employees, otherwise they're going to flee. And so the debtor has to get permission from the court to be able to use that money to pay the employees. With regard to selling, that is even more so forbidden to the debtor without the court's permission. So if the debtor wants to sell something, let's say a piece of real estate, the debtor has to get the court's permission, and the sale has to take place in the bankruptcy court itself. As I said earlier, there is typically an auction, and there are bidders that come and bid on that asset, and the highest bidder, of course, gets the asset. So that is under the aegis of the bankruptcy court. And similarly with leasing of the property. Now you might wonder, why is all of this micromanaging taking place? Well, remember, we said earlier that upon filing the bankruptcy papers, the act of filing those papers creates a bankruptcy estate. And everything in that the debtor has goes into that estate. And it's to be managed by that debtor in possession, for the benefit of the creditors. So in order to make sure that it is being managed for the benefit of the creditors, there is that judicial oversight. So those limitations can be summed up as, you got to get the court's permission.